Dungannon after your long march, and congratulations. More and more lately, a terrible incident comes back to me from the past. I was chaplain of the women's prison in Armagh for 19 years, 1967 to 1986. Marion and Dollars Price were prisoners there within that period, and I was well acquainted with them. In March 1975, they were transferred from Durham Prison to Armagh Jail. In England, they had been on hunger strike, a protest to be returned to prison at home. They had been forcibly fed. They ended their strike after 206 days. It took its toll on them. During their imprisonment, both sisters suffered from severe illnesses. I will never forget visiting Dollars in 1981 in the security wing of the Musgrave Hospital. This wing was under armed guard. Dollars was brought down a corridor to me in a wheelchair. She looked like a skeleton. I will never forget it. She was handcuffed to the wheelchair. So severe was the sickness that both Marion and Dollars received an accelerated release. Cardinal Tommaso Fee, the papal nuncio, the Taoiseach, were among the many concerned people who pleaded for their release on the grounds of ill health. Unfortunately, even after their release, they suffered from recurring illnesses. Then, after 37 years, what has happened? Marion Price was interned by the Secretary of State, Owen Paterson. In a letter, I asked him, did he, before interning her, study her medical reports of 1980, when she was released from jail? She was near to death. He never answered that question. It was inevitable that in the close condition of prison and in solitary confinement that her severe illnesses would return. This 58-year-old woman is seriously ill in Windsor House, the City Hospital, Belfast. History has repeated itself. Internment is back. The sick prisoner handcuffed, even under guard. Marion Price McGlinchey has now served 16 months in prison, the equivalent of 3 years jail. Look back over the past week and more. Marion was told in the morning of the 16th of August that she was to be taken to another hospital for treatment. The appointment was scheduled for the same afternoon. Prison officers entered Marion's hospital ward and double handcuffed her, both hands cuffed together and another handcuff attached to a prison officer. Marion was transported to Musgrave Park Hospital, where a PSNI presence was very obvious both inside and outside the building. 2 PSNI officers and 3 members of the Prison Officers Association accompanied Marion throughout the hospital visit. In addition, other PSNI personnel were in close proximity. Throughout the treatment, the 2 PSNI officers stood just outside the door, and the prison staff were also present. Marion received the first of the steroid injections aimed at addressing a serious flare-up of her chronic arthritic condition. She has also been on a list to receive innovative treatment which may help alleviate some of the severe pain she is enduring. During the consultation, Marion had to produce a urine sample and was escorted to the cubicle by all the prison staff and both PSNI officers. The public and patients witnessed this whole exercise. Marion was handcuffed again after treatment and returned to the hospital unit she is presently held in. It is important to note that this was the first time throughout Marion's present imprisonment that this practice has taken place. The old methods of cruelty are now returning. Who is giving these orders? Marion in recent years had a wrist joint replacement and other surgery to her hands in Musgrave Park Hospital. It was noted on her return from Musgrave on the 16th of August that both her wrists were bruised and swollen. Marion herself was extremely unwell. She has been prescribed 18 different types of medication which she receives on a daily basis. Her family has been informed that there is no improvement in her condition and that other drugs are presently under consideration. On the morning of the 17th of August, Marion was told she was to have a lung wash and endoscope. As you know, she has been suffering from pneumonia. Marion has been treated for TB in the past and at this present is receiving treatment for pneumonia. A prison officer entered the ward again and told Marion she had instructions that again handcuffs were to be used during the move to the operating theatre. Marion asked that a doctor look at her wrists. The trainee doctor noted that her wrists were bruised and swollen and contacted a senior doctor who spoke to the hospital's legal representative. It was made very clear that Marion was not to be cuffed, and this message was conveyed by the legal representative directly to a doctor who said he would get the directive to the prison officers. A letter had been issued by a female governor in the Hyde Bank prison on the 22nd of June when Marion was transferred to hospital. This letter contained very detailed instructions which the prison staff had to follow. The prison staff involved in the cuffing on both days are not responsible for these actions. They were told by the prison to follow the instructions in the letter. A doctor informed the family that while Marion had already been taken to the theatre cuffed before a representative of the prison service gave instructions, and his instructions were followed. The directive should have been passed on to prison officers during Marion's operation, which would have negated cuffing on her return to the secure hospital unit. The prison officers did not receive the instruction and were therefore bound to adhere to the letter of the 22nd of June last, signed by the female governor. During Marion's operation, a prison officer remained in the theatre. The consultant asked that the officer leave and go to the other side of the door. She told him that she had to follow the instructions set out by the female Hyde Bank governor. This meant that Marion was never to be out of sight. Before the operation, Marion told the consultant that she had endured sustained forced feeding in the past and was deeply traumatized by the experience. She asked that this be taken into account before he commenced discussion and during the operation, this intimate discussion. Marion was anaesthetized and when the operation completed, handcuffed and returned again by ambulance to the secure hospital unit. Marion has been degraded and humiliated while being both mentally and physically extremely ill. When her family saw her on the 17th of August, she was very distressed and unwell. I saw her in August myself. I was shocked by her pallor. Marion is now worse than she's ever been. A consultant says she should be treated at home. So do we. The case of Marion Price is familiar to you now. Thousands of letters have poured into the Secretary of State, Owen Paterson, not only from Ireland, where many meetings have been held in Derry, Belfast, Coalisland and Dublin, but also from the USA and from many human rights organisations. The Secretary of State, as you know, revoked Marion Price's licence after the judge had granted her bail in a court case, a case that has now been dropped. This severe action has had strong repercussions among the nationalist community who look upon its action as a form of internment. Internment, mainly against Catholics in the 1970s, was one of the main causes of the continuation of conflict in the North and followed the tradition of the British government, who had cruelly imposed internment on nationalists in every decade of the Stormont government regime. Did you ever imagine that internment would return? Mr. Paterson, by this state violence, is harming the peace process. Almost every day, letters appear in the media condemning his actions and the attitudes of the British government in the cases of Marion Price, Martin Corey and Jerry McGowan. The cruel attitude of the Secretary of State has again been shown in the question of pardon, the royal prerogative of mercy, granted to Murray in 1980. As you know, the public have been astounded to learn that the British authorities either shredded the document or just cannot find it, or so they say. They have failed to locate it. How can Mr. Patterson say, as he does, that it applied only to a 20-year sentence and not to the life sentence, which he cannot when he cannot produce the document? He falls back in letters on a phrase, "We have information." Are we to be ruled by MI5? That is a dangerous phrase coming from Owen Patterson. How can Murray and Price be deemed as a risk to others? Last week, a strong editorial headed "Internment Again" appeared in the Irish Catholic. It said, "One of the hallmarks of a just society is due process and the right of those suspected of crime to have the evidence, if there is any, sent before a legitimately convened court. We want a normal, peaceful society imbued with truth and justice. We want an end to special courts, those non-jury diplomat courts. The use of diplomat courts during the conflict in the north of Ireland occurred in a context of diminishing confidence in the law, and especially among the Catholic population. It went with Special Powers Acts, emergency laws not used impartially but abused, internment, torture and cruel, inhuman and degrading treatment, ill treatment illegally by agents of the law, use of verbal statements and supergrasses, blackmail of young persons by security forces, semi-official assassinations, collusion of security forces with loyalist paramilitaries, and official shoot-to-kill policies. Even in prison, as I well remember having attended, even in prison, injustice continued for internees. The injustice of the long case, so-called appeal tribunals of 1972 still haunt us. There must no longer remain in the north of Ireland a trace of the violation of law by government in its laws and its law agents. Confidence in the law is extremely important. Diplomat courts were not acceptable, and present traces of its workings in the Justice and Security NI Act 2007 in non-jury courts with their aura of injustice are not acceptable. The rule of law in the north of Ireland was corrupted by the use of illegal methods of interrogation and by the official efforts to cover up the use of these methods. The end can never justify the means. Justice, not expediency, is always the principle. Justice, freedom and truth are held by jury courts. Confidence in the protection of the law is vital to a free society. To retain non-jury courts for certain individuals leads to selectivity and the danger of prejudice. If this is seen in prosecution and preferring of charges, then confidence in the courts is undermined. It casts doubts on the objectivity of law officers of the Crown and the police. Law officers depend on security forces, intelligence so-called, for information about crimes committed by private individuals thought to be members of formerly members of prescribed organisations, and are therefore limited by the quality of their sources of information. Selectivity at stages of the application of the law disturbs peace and justice. During the conflict, Catholics, nationalists felt they were denied civil rights and legal justice. This led to alienation. Any measure that indicates retention of selectivity casts doubts on the practice of justice. In the period of conflict, Father Dennis Fall and I called for an end to the special diplomat courts where alleged verbal statements of an accused man were given out by the police and accepted on their word, were beating, thumping and kicking prisoners and interrogating them for long periods and putting them in positions of stress, were not accepted as cruel and degrading treatment, and statements taken after these forms of ill treatment were accepted in court. Furthermore, there was a great disparity in sentences, and some of the sentences inhuman, 20, 25, 30 years recommended. All traces of deadlock courts must go. Human rights and civil liberties in the north of Ireland should be restored in full and protected by safeguards of the ordinary criminal law. The right to public and fair trial is restricted by non-jury courts. The right to trial by jury is a precious legal and civil right. The creation of just structures of law in society must ensure full restoration of trial by jury. It is a question of justice. For a citizen to have even a small measure of freedom and fair play, it is necessary for the legislature, the judiciary and the executive in the country to be completely independent. Confidence in the law must be maintained and promoted. The state is the servant of its citizens, not the master. Mr. Patterson should remember that he is our servant, not our master. Juries are seen as an important check against state power. The system provides a means of interjecting in community norms and values, interjecting them into the judicial proceedings. There is more risk that the administration of justice might be impaired if the trial is to be conducted as they are without a jury. When you study the cases of Marion Price McGlinchey, Jenny McGow and Martin Corey, do you despair of justice? Their families and friends are suffering grievously. We demand their release. No, I will never forget the symbolic cruelty of 1981, the skeleton Dollars Price handcuffed to the wheelchair in a security ward, and that now, 30 months later, her sister Marion has suffered the same thing. And will you ever forget the distress of the Finucane family outside 10 Downing Street after David Cameron and Owen Patterson informed them that they were not to have a truly independent inquiry into the murder of Pat Finucane? Was the refusal because it would reveal indirect British government involvement in the murder? Gur míle maith agad.